Well, in the past 2 months, we've seen two local cases in which an alleged rapist has been set free because of failures in part of law enforcement. Well, in one case, the defendant, Andre Bird, was charged with raping a Niskayuna woman in May of 2010, but then was set free after the police investigation stalled for nearly 2 years. And of course, I think you're very familiar with the second case, John Hallisey, who had been charged with raping two children, but then was let go after the Rensselaer County District Attorney's Office violated his right to a speedy trial. Here to break down these two cases for us is attorney Paul Harding from the law firm of Martin, Harding and Mazzotti. And Paul, always good to have you with us, and great to have you react for us to something right off the headlines here. Let's talk about the John Hallisey case, because I mean that just raised so many eyebrows. Why was it essentially dismissed?
Case. Again, we're going back a few weeks ago. We have a situation where it was a clear violation of a speedy trial rule, a CPLL 3030 rule to be official. But within 6 months, the people have to be ready for trial. Now, oftentimes that is delayed and things like that. But in this case, there was absolutely no choice that the judge had but to dismiss that case.
So, okay, so we have that happen, but all felony criminal cases, do they have to be brought to trial within 6 months?
Yeah, in fact, few are. What happens normally is the defendant will waive their right to a speedy trial. It happens all the time, or within that 6 months, a lot of delays are attributable to the defendant. And if that's the case, the prosecution gets to kind of extend that time. So it was an exception when that happened. And then, as you point out at the beginning of the story, something similar to it has happened again.
Yeah. Can the police or the DA maybe look to bring the charges again or appeal? I mean, we've seen things happen in the Hallisey case where different charges, lesser charges were brought.
Yeah. In the Hallisey case, no. That is finished and done. Two reasons. One is it was statutory. The judge, again, didn't have much of a decision. And two, he ended up pleading to a lesser charge, as you pointed out, which sort of wrapped everything up. And so there's no appeal at all in that case.
And how about the, how was that one different, say, from this more recent case in Niskayuna with Andre Bird?
It's one of those cases that came about with Andre Bird. You know, the facts are just, you know, they're so egregious, equally egregious when you hear about them, but they really are different cases. In this case, 2010, there's a woman who's allegedly raped. And the defendant, Mr. Bird, a year later, the DNA kind of links him to her, and that's sort of where it ends. At that point, they talk to him. He says, hey, this was consensual, or he has some defense that he wants to mount. 22 months pass. It then gets put in front, brought to the district attorney's office, who then brings the case, and then the case gets dismissed. So it's not a situation where the DA had this thing for a very long time. The police had it for a long time. The interesting part is here, the judge found that the police didn't do enough or virtually anything in those 22 months, and therefore felt that Mr. Bird would be prejudiced, and then has dismissed that case.
Can you just tell me quickly then, is this the same as Hallisey, or can he face those charges again?
Yeah, this is different. This is judicial discretion. It's not statutory. I spoke to a few criminal attorneys, criminal defense attorneys, and they are split. They think that the appellate division is going to look at this and maybe reverse it, but we don't know. We'll have to find out. All
right. Fascinating stuff today. Thank you very much for sharing your expertise with us. And if you have a question for Paul Harding, you can email it to whatariyourrights@cbs6albany.com. And Nick is up with your complete forecast after the break.